This is Bloomberg Law with June Grasso from Bloomberg Radio.
Fresh off his victory in the Iowa Republican caucuses, Donald Trump spent much of the day in a Manhattan courtroom at the next trial in his crowded legal calendar. This time in a defamation lawsuit by E. Jean Carroll, the writer who won a separate sexual abuse case against him last year. Trump has continued to rail against Carroll despite that verdict, as he did in an impromptu press conference during the closing arguments last week in the New York AG's civil fraud lawsuit against him.
I have no idea who this woman is. I have absolutely no idea. The whole thing is ridiculous that this is even a case. This should never have happened. But again, this is sponsored by the Democrats. It's another case.
My guest is Dave Aronberg, Palm Beach County State Attorney. Donald Trump continues his tour of courtrooms around the country, like the D.C. Appellate Court last week. He doesn't have to be in the courtroom, but he is for the very beginning of the trial. So what do you make of this? Is he trying to impact the jury or impact the voters?
Impact the voters. This is all about public relations. This case has already been lost. The judge said we're not going to relitigate the past trial, which said, according to the jury, that Donald Trump committed sexual assault against E. Jean Carroll and committed defamation against her. So now we're just talking about damages. How many millions in compensatory and possible punitive damages will be assessed? So the only reason why Trump is there, I think, is to try to gain political points, to show that he is being derided as the leading candidate for president. This is the Biden administration doing this, even though that doesn't make sense. And ultimately, nothing fuels his MAGA base more than martyrdom and grievance.
I want to talk about what his defense could possibly be here, because the judge has basically cut off every avenue of defense that I can see. He can't deny that sexual abuse happened or that he believed his statements were true. He can't comment on Carroll's prior romantic relationships or the lack of DNA. I mean, what is his defense here?
He doesn't have a defense. In fact, I don't think it's a good move for him to try to testify, because if he tries to pull what he did in the New York civil fraud trial, in this trial, he's going to get sanctioned. He's going to get cut off. This is a jury trial. This is not a bench trial like the last trial. And you have a federal judge and Judge Kaplan who's not messing around. Judge Engoron, a state court judge in New York, gave him a wider latitude, and he allowed Trump to bash the judge and the process and the attorneys. That's not going to happen here. And in this case, he's limited to what he can say. As you correctly pointed out, they can't relitigate the last case. He can't attack E. Jean Carroll. And so what is he going to say? He's not going to be able to go on a political rant. So there really is nothing he could say that could influence a jury here. Best he just not testify at all.
So he says he wants to testify. Of course, he said he wanted to testify at the last E. Jean Carroll trial. So who knows? The judge is saying that he can do so if he wants to testify on Monday, January 22nd, which is the day before the New Hampshire primary. So maybe.
Maybe. Well, he had a lawyer the last time, this Tacopina guy. Yeah. And Tacopina and Trump split up. They just had a divorce, and he's being represented now, Trump is, by Alina Habba. And Alina Habba is gung-ho on Trump testifying. The word was that Tacopina did not want Trump to testify. So this is Trump saying, I am going to do it. I am going to show that the whole process is a fraud. But he's not going to be allowed to testify that way. So in the end, I think he just does what he's done before, which is to promise that he's going to testify. But then in the end, he does not.
So Joe Tacopina is a well-experienced trial lawyer. So there is the reason why he doesn't want Trump to testify. Alina Habba, I don't think, has much trial experience at all. And again, today she was, the same thing that happened in the trial, the New York trial. They seem to be trying to get on the judge's bad side, challenging the judge and, arguing with the judge. I mean, in the trial that ended last week with Judge Engoron, it was crazy, some of the things that they did and said to this judge who was going to be making the decision without a jury. So I'm not sure about her courtroom tactics.
Now, one of the first things they teach you in law school is never upset the person wearing the black robe and wielding that gavel. big mistake, but yet they keep doing it, and they got away with it with the Judge Engoron because they knew their goose was cooked in the New York civil fraud case. So what do they have to lose? But by attacking Judge Engoron, I think it gave Trump a false sense of confidence that he can do it again. This is a federal judge. We're talking about lifetime appointments, and these guys run their courtroom like a tight ship, and there's no way that Trump's going to be able to get away with any of this stuff, especially because it is a jury trial. So although he promises he's going to testify, I think this is like other promises where he's promised to testify earlier in the New York civil fraud case, which then he didn't do, or in the first trial in this matter, he said he would testify and he didn't do, just like he said he would meet with Bob Mueller during the investigation, which he didn't do, and just like he said he was going to have a health care plan that comes out in 2 weeks.
Oh, you're going back far now, but you have a lot to work with. So what's interesting is the counsel for E. Jean Carroll, Roberta Kaplan, expressed concern in recent days that Trump would attempt to turn the trial into a circus, and she suggested the judge be prepared to hold Trump or his lawyers in contempt of court or issue punitive fines and monetary sanctions. Was that necessary for her or just for publicity? Everyone knows Judge Kaplan. Judge Kaplan is no nonsense, and he doesn't need, it seems to me, direction from an attorney how to run his courtroom.
I agree. Judge Kaplan is not going to suffer fools lightly, and I do understand why Ms. Kaplan, no relation, E. Jean Carroll's lawyer, wanted Trump to say under oath that I will not violate the court's order. But you know what? She also wanted Trump to admit under oath that he committed sexual assault against E. Jean Carroll. And although the jury found it, in our country, we still don't force defendants to incriminate themselves or to say certain things like, I did it, I'm guilty. So I think she was asking for too much, and the judge is not going to go there.
What's unusual in this case is you talk about secret juries, anonymous juries. This jury is so anonymous that the judge told potential jurors that if they're selected for the trial, they should use fake names when discussing the case with each other. And they wouldn't be permitted to disclose their role to anyone, including family members.
Yeah, I've seen anonymous juries before, but I've never seen an order where you can't even communicate with each other using your real name. But it makes sense. You want this to be airtight. But it really tells you what kind of political culture we're in now, what kind of country we're in now, where you have the threat of violence against your political and legal opponents that's so pervasive that you need an anonymous jury like you do in mafia cases when you are trying a former president and the leading candidate for president in the Republican side. This should never be normalized. The fact that the person who won the Iowa caucuses has to get on a plane and go to a courtroom where he's already been found liable for sexual assault should never be normalized in this country.
Well, also, increasingly, judges are being threatened. In fact, in the civil fraud trial, before the closing arguments, Judge Engoron was also threatened.
Yeah, judges get their houses swatted, they get threatened, their families get threatened, and, we just seem to accept it. This is not how a functioning democracy is supposed to work. We're not a fascist country, at least not yet, and you're not supposed to threaten your political or legal enemies. But that is what certain elements of the MAGA movement have done. And look, it's not everyone, but you have extremists within the movement who think that anyone who attacks the leader needs to be threatened and really possibly even killed. And that is absolutely unacceptable. And we need leaders to stand up and say, no, this is not to go on any longer.
What's curious, he's escalated his attacks against E. Jean Carroll. He's repeated what's already been determined in the last trial to be defamatory. So it wasn't after the closing arguments last week. It was during the New York Attorney General's closing arguments. Trump held his own press conference downtown, and he repeated that he'd never heard of her before. He didn't know who she was. So, we're going to keep having trial after trial after trial if he repeats the defamation?
Yes, until the cost of saying these things is so great, where he gets hit with such punitive damages that it's not worth it anymore. So one of two things has to happen for this to stop. Either the punitive damages in this case or a subsequent case has to be so great that he decides it's not worth it, or he actually gets a political hit from it where his poll numbers drop, and then I think he'll back away from it. But right now, neither of these things has happened. He got fined $5 million in the first case. That's not enough for him to change his behavior, and he just won the Iowa caucus. So as long as he keeps winning, he's not going to change his behavior.
Let's turn to Trump's claim of absolute presidential immunity in the D.C. Circuit Court. And the question that was heard round the country from Judge Florence Pan about whether or not you could assassinate your political rivals and get away with it because of presidential immunity. Do you think that's going to come fast, that decision?
I do, and you can see by the judge's questioning. It was just such a no-brainer where, of course, a president doesn't have absolute immunity. Of course, they can't kill their political rivals. And look, it's not so funny when it happens to the other guy. So if you give Joe Biden this kind of power, he can cancel the election, arrest Donald Trump, and be president for life. So, of course, they're not going to rule for absolute immunity. Now, the question is, how long will the decision take? I think it'll be soon. The D.C. Circuit Court of Appeals has expedited its review. And then the question is when, it's not an if, when D.C. Circuit rules against Trump. What does the Supreme Court do? I would bet that they're going to defer to the D.C. Circuit and deny review, and then it's game on in the election interference case in Washington, D.C.
I agree with you. I think we're in the minority. I think a lot of legal scholars, legal experts think the Supreme Court has to take that case, has to make the decision, but they already have so many different issues related to the election coming up that I'm not sure they want to go into another one yet.
Right. And this is a no-brainer. This is not a hard one. And the Supreme Court, I think, would rather deal with other things. And it'd be easy. I think the reason why the Supreme Court, one of the reasons why they denied their own expedited review, because remember, Jack Smith wanted the Supreme Court to Bigfoot the D.C. Circuit Court of Appeals, and they said, no, we're going to let the D.C. Circuit handle it. I think one reason why they did that was that they were going to defer to the ruling of the D.C. Circuit, knowing they would deny presidential absolute immunity.
And do you think that the decision will just be we're denying absolute presidential immunity, or the judges might have to set out some of the parameters where presidential immunity might apply?
Judges generally like to rule on the narrowest issue possible. Don't get too ambitious, especially when there's an expedited review. So I think they're just going to deny it here. I don't think they're going to go much further, because you do that, then you open it up to more delays. And this case, the one in Washington, D.C. for election interference, is the one that's most likely to be tried before the election. It's, in that sense, the most important case, because all the others, I think, with the possible exception of the New York State case on Stormy Daniels, will be tried after the election. So that's why I think these courts want to get it started as soon as possible.
The judge, Judge Tanya Chutkan, has not, she's sort of put everything on hold, but she hasn't actually, taken it off the docket, the March 5th trial. Do you think that there's any way they could meet that? If, let's say, the D.C. Circuit comes down this week and says no presidential immunity, the Supreme Court says, no, we're not going to review it, how long?
Oh, then it's immediate. I think also the D.C. Circuit will remove the stay of the case immediately, and then it goes to Tanya Chutkan, Judge Chutkan. She will calendar it. Now, it's set for March 4th. I think within 60 days of that is the trial day. That's what I have been saying from the beginning. I'm going to stick to my prediction, and this case will be decided well before the election. And you see the polls, even though Trump won pretty handily in Iowa, still a certain segment that says if he's found guilty in one of these trials, people would switch their vote away from him.
What about your Florida trial down there on classified documents? You have a date for that?
It's scheduled to go in May. It ain't going. Here's the thing. Judge Cannon is slow-walking this case. That case in my neck of the woods is the strongest of all the 4 cases against Trump. He has no defense, but that case is going to be delayed past the election, and that's a shame.
It's great to have you on the show, Dave. Thanks so much. That's Palm Beach County State Attorney Dave Aronberg. And now turning to tensions at the border. The drowning deaths of a woman and 2 children in the Rio Grande River as they tried to enter the United States from Mexico on Friday have intensified tensions between Texas and the federal border officials. U.S. border officials say Texas officers prevented federal border officials from helping them. Joining me is Leon Fresco, a partner at Holland Knight and the former head of the Office of Immigration Litigation in the Obama administration. Leon, what happened? What do we know happened on Friday? Because it seems like there were conflicting reports.
Well, there were conflicting reports, including one from Congressman Henry Cuellar, who's the esteemed congressman along the border. And so the Department of Justice actually filed a brief in the Supreme Court that actually discussed this issue slightly more. And it seems like there were 6 migrants that were actually in distress. So the Mexican government reported this to the Department of Homeland Security. And by the time the Department of Homeland Security would have responded, it seems like, even if Texas had let them in, 3 of them would have already been found deceased, unfortunately. There were 2 others that were rescued by the Mexican government that presumably would have been rescued by the Border Patrol had they been allowed to enter. But there is no dispute that the Texas state officials are blocking this park in Eagle Pass, Texas, and not permitting the Department of Homeland Security officials enter the park, which the Department of Homeland Security officials say is a violation of their right to enter in times of emergency, that they have a federal right under the Supremacy Clause to do that.
And which side do you agree with? Does Texas have the right, or does the Department of Homeland Security have the right?
It's clear that if there's any kind of transnational emergency that's happening on the border, that the federal officials have the ability to access the border to be able to respond to that transnational emergency. Where they can't necessarily do things is if they were just patrolling this park and the state of Texas said, this is our park to patrol, the federal officials don't have jurisdiction here, that's fine. But in these situations of an emergency, there's no doubt that the federal government has the authority to enter. And so the Texas government not allowing them to enter will probably lead at some point to some sort of injunctive relief that will then, if it happens again, could lead to contempt of court findings.
So Texas Governor Greg Abbott has been escalating the tensions with the federal government over immigration at the border. Was this part of the new law that's been passed where Texas says that its local officers can arrest migrants, which is normally a job for the federal government?
Well, this is part of that overall strategy. The law itself, what it's going to do is it's going to say that if you're not in Texas legally, it's a misdemeanor that you can then be taken to the border. And if you don't actually cross back into Mexico, you can be rearrested again for a felony. And so all of these areas that are being enclosed are part of this overall strategy to be able to have places to take people to along the border and say, here are your 2 choices. Either go back into Mexico, or if you try to come back in, we will arrest you under the Texas law. Of course, the legality of that Texas law is currently under review at the courts and is probably going to work its way all the way up to the Supreme Court.
So, Leon, this is all part of the bigger problem of immigration and the security at the southern border. And in the Iowa caucuses, that was one of the major concerns of the caucus goers there. What is the status of negotiations over immigration?
Well, one of the biggest problems happened the last few days where House Speaker Mike Johnson said that he thought that there wasn't any legislation that would be able to be created by this Senate group of negotiators that would be acceptable to the House, such that this needed President Trump to be able to come in and be able to solve this problem. And that what President Biden needed to do was just unilaterally act with any powers that he had, but that the legislation to solve the border problem would be too weak if it was the current legislation that's being talked about by the Senate. I don't think that's going to be the last word. I think that's posturing in many cases. I do think the White House wants a deal. The White House has actually brought in all the relevant negotiators and chairmen to speak today at the White House to try to get a deal. The White House very much wants a deal. They're negotiating in areas that make many very Democrats very uncomfortable with regard to what kinds of limitations they're willing to accept along the border. But at the end of the day, it's going to come down to, can the Senate pass something? And if the Senate can pass something on a bipartisan basis, then they can make the House look really badly. If they refuse to pass something, then it becomes evident that the House would be the ones blocking progress.
And there are some areas where the Senate negotiators have come to agreement, right?
Absolutely. The Senate has some spots with regard to sort of a re-implementation of Title 42 authority, which was the authority to automatically expel people at the border who don't come in through the ports of entry, who actually try to come in illegally in between the ports of entry, with limited exceptions for very extreme humanitarian cases. Also an expansion of detention for those kinds of people who enter the United States and are waiting for their cases to be heard. But the area that's not yet resolved is there are these 30,000 people per month that the Biden administration is allowing legally to enter the United States from Cuba, Haiti, Nicaragua, and Venezuela, that the Biden administration argues is necessary so that people don't enter illegally, so that people wait in their countries and apply for this program. The Republicans want that program eliminated, and they also want it to be eliminated that basically under almost all circumstances that the Biden administration couldn't find someone with urgent circumstances on the border and admit them in legally. And so those two areas are under debate about whether those will be accomplished or not.
Thanks so much, Leon. That's Leon Fresco, a partner at Holland Knight. Will artificial intelligence change the legal profession? Or a better question may be, just how much will artificial intelligence change the legal profession? In fact, AI has already taken some of the drudge work out of legal work. But a study last year by researchers at Princeton University, the University of Pennsylvania, and New York University concluded that the industry most exposed to the new AI was legal services. And a research report by Goldman Sachs estimated that 44% of legal work could be automated. Federal judges have begun implementing checks around the use of AI in court filings by issuing standing orders. And the global head of AI at Ropes and Gray, Shannon Kirk, and her colleague Amy Longo have developed an AI court order tracker that examines standing orders and local rules on the use of AI in connection with court filings. She joins me now. Shannon, before we get to your tracker, tell me what the main concerns of lawyers are about AI.
I think it has to really, the concerns when you talk about lawyers' concerns regarding AI depends on what practice group you're in, right? So generally I can speak to what I focus on, which is litigation and our concerns with respect to, quote, AI in litigation, right? And so that runs the spectrum of concerns. One of them would be a concern that we've always had for all litigators at all times, which is how to train our junior classes. That concern is amplified now, and we can talk about that if you want, with Gen AI, right? So that's one concern. Another concern that I'm particularly focused on is how sophisticated are the courts and my opponents and regulators going to be when we talk about Gen AI, right? And that's partially why we have the tracker, is tracking how sophisticated and specific and precise everyone is being in the law when we talk about Gen AI versus, quote, this big global scary thing called AI, right? Another concern, of course, is how Gen AI, when it actually is deployed in litigation, will change staffing, will change budgeting, and therefore change how firms are comprised and how we hire and how we bill. So there's a lot of concerns. I sort of hesitate using the word concern because it implies that I think it's negative. Right? I don't. I think that there are some sort of concerning things that maybe some folks would see as negative. But I think that it's all about, appreciating those concerns in the context of how are we going to adapt to all of it, because we have to.
Do lawyers think that this will mean that less lawyers will be needed in the future because AI will be doing some of that work, especially the groundwork or the work that, associates might end up doing?
Right. I think that's sort of inevitable that there will be, for certain functions in litigation, less need for that junior rank. And so we saw this already in the uptick in use. It took, in my estimation, about 10 years in the wider adoption of predictive coding, right, or TAR, technology-assisted review, et cetera. And so when I started out as a junior lawyer 25 years ago, we used to all slog through documents one by one in a linear fashion, or we used to sit in a warehouse for months going through boxes, right? And it would take, obviously, staffing-wise, a lot of us. That's a lot of us first years, second years, third years. Then around-ish 2008, we start seeing predictive coding, TAR 1.0, et cetera. I get my job full-time as an e-discovery lawyer in 2008. And what we started to see was a reduction in the need for big armies of contract attorneys and a ton of firm attorneys doing document review, right? So you can just track that. I think with Gen AI, it's inevitable, right? A portion of that document review, so that slice of lawyer life of document review, will eventually transition to prompt and prompt engineers and, figuring out how to design the query of the Gen AI tool to bring back items that are, quote, relevant or hit a certain qualification. That's going to take less lawyers. What you'll need then is to develop the expertise in the junior ranks on how to QC that output and what to do with it, right? It's a long way of saying that this, to me, is just another evolution of that staffing reduction, which means a shifting of what we do with our junior lawyers and how we train them.
Is there a general concern among lawyers that opposing counsel may be drafting filings using generative AI?
I think if you read the headlines, you might have that sense that there's this overarching fear that your opponents are doing that. I personally don't have that concern. When you look at the numbers, right, I've been able to track 3 court orders where lawyers were sanctioned for using hallucinations in court filings. And so that's, those are headline-grabbing things that people focus on. In reality, do I think generally we're all talking about a concern that lawyers out there are going to be using hallucinations and false case law? Sure. We always have concerns that opposing counsel is not exactly, citing cases accurately. And so this is just more of that, right? Whether they're citing inaccurately or just citing totally fake cases. It's difficult for me really to say that that's an overarching concern because I'm at a big law firm, and you would expect our opposing counsel in our types of cases to be really doing their homework because, of course, if someone cited a fake case in opposition to something I filed or any of our lawyers filed, we would seize on that, right? So what would concern me more, and does concern me, is access to justice, right? And making sure that our pro se litigants, our pro bono litigants who have less resources do have access to these powerful tools, but know how to use them and know the pitfalls. That is what would concern me and does concern me. Those headlines, those scary headlines, and there's really only been a handful of people being, not very bright in using these tools, they don't help us as a legal profession make sure that there is access to justice and that there are pro bono litigants that could responsibly use these tools, right? It creates this fear factor. And then we get to our tracker, and you'll see there's a couple of courts that have all out banned the use of these tools because I think it's in reaction to those handful of headline-grabbing cases.
So now tell us about the AI tracker you've developed.
Sure. So the tracker, for me, it has 2 purposes, right? For one, it is diagnostic for my role at the firm. And then the other piece of it is just a practical tool for any lawyer or anybody in court who wants to see, hey, I'm in the District of Hawaii. What do they have any standing orders on AI or Gen AI? And it's meant to be interactive and visual, so it's easy to use for that purpose. For my purpose, I am the global head of advanced e-discovery and AI strategy at Ropes. And so I am asked almost on a daily basis now what my prediction is for the adoption of Gen AI in the law, in litigation, right? And so I could maybe just answer that off the cuff, what my predictions are, but I've tried to have some diagnostic tools thrown out there, sort of like if we were scientists at one of the poles trying to gauge and predict global warming, there would be a bunch of sensors and probes out there. So that's how I think of the tracker. And so the tracker for me is telling me, okay, as of today, January 16th, we have 23 different courts issuing some kind of order on AI or Gen AI. And then when you dig into it in our tracker, we've got layers of analysis on what they are, and then we're also tracking over time how they evolve, how they become more sophisticated, and we're already seeing that. And so that diagnostic of analyzing that helps me to answer that question. What do I think the next year or two are going to look like for the adoption and actual use of Gen AI in litigation?
What kind of trends do you see, if you see any trends in these court orders?
What I'm seeing is interesting. So what I'm seeing is we had a bunch come in November and early December, first of all. So I'm seeing an increase of just courts issuing standing orders, number one. So that helps me to predict, based on last year's activity and where we are with the courts, we're going to get more over 2024. The second trend I'm seeing is that they're getting more precise and therefore sophisticated. In other words, earlier ones, there's a few that were a little too general, right? They just referred to, quote, AI generally, which is hard for practitioners who don't live in this space to appreciate what are they talking about, right? Are they talking about an AI tool that generates information, or are they talking about a wide definition that could apply to really any automated software? So we're seeing more sophistication on that front in getting there. And then we're seeing much more specificity around the tools that the courts are concerned with. And for example, if you look at the Northern District of California, November 22nd order from Judge Martinez Alguin, that order is requiring lawyers to maintain records of prompts and inquiries. So that's one of the more specific ones that I've seen, and that's that evolution or trend. I expect to see more of that over 2024.
Are there any judges' orders that you find troubling or, involve too much?
I don't want to be critical of any of these court orders because I think they're all doing a great job at just trying to focus the bar on concerns, and that's always good. I would say if you were to compare the Eastern District of Pennsylvania, so Judge Bailson, right, that's an earlier one. So that's from June. And I would say that that's fairly generic, and it doesn't refer necessarily to Gen AI, but AI in general. And the other concern with it is it's not directed to just actual court filings, but also the preparation of any complaint, answer, motion, brief, or other paper, right? So that's pretty widespread and could apply to really any work that lawyers are doing if it winds up in a filing. So over last year, what we saw was these court orders got a little more specific on being applicable when you actually file something as opposed to the preparation of something. So those are the two concerns that I look at when these court orders come out. And one of them is it specific to Gen AI? Is it being clear? And then the second is it applicable to an actual filing or submission or all of the preliminary work and research? Because that becomes a little bit more difficult to adhere to. On the flip side, the other end of the spectrum are court orders that embrace the fact that really under the existing rules, you already have a duty to certify accuracy of your filings.
Thanks so much, Shannon, for sharing your tracker with us. That's Shannon Kirk, the Global Head of AI at Ropes and Gray. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.